no charges filed. We just left the jail. We went. We monitored for the next month the DA and the court docket. Our names never appeared on the court docket, and the DA never filed charges. So I received an acting award up in Vancouver. My wife and I thought it would be a good time to just go up there and receive this award and come back. We're only there for, going to be there for 4 days. The day after we went to Canada, they charged us with failure to appear, and that's when they filed the charges the very day they alleged we were supposed to appear, an appearance for which we received no notice. Those $50,000 bonds that they said we took out, we never took out. The bail bondsman filed them behind our backs without our knowledge and never gave us a notice or a date. So those bonds were supposedly forfeited on the October 18th hearing. But in the oral transcript, the written transcript and the audio transcript, there's nothing to indicate the business of forfeiture was discussed or that the sufficient excuse was offered. They were not forfeited in that hearing yet. The court clerk in Santa Barbara filled out the minutes. The bond was forfeited. He filed a notice of forfeiture saying that these $50,000 bonds had been forfeited, even though there was no business of forfeiture in the transcript or in the hearing. Okay, so we're in Vancouver. The DA, Lee Carter, calls immigration, says pick them up. They're fleeing warrants, they're fleeing these bonds, and they promised to appear. And we heard about it through the internet that we missed his court appearance that we didn't know anything about. And we checked the docket again immediately. Our names were still not on the docket on the website. We later found out from the supervisor of court records that our name was never on for an October 18th appearance or any appearance. And so they picked us up, Canadian Border Services, and we were detained for 6 days. And as they're going to release us and take us back to the border. During that time, the next to last day, we contact bail bondsman, the same bail bondsman that filed the bonds, the $50,000 bonds without our notice, because he had worked with us on a previous case that involved a credit card, my wife's credit card. I was acquitted of all that, and my wife received minor community service with no stipulations restricting her travel or anything, just fulfill the hours within a 1-year time limit. So he was the only game in town for us. Nobody would touch us because they'd heard on the news that we were fleeing these bonds and skipped and all that. So we called him and he said, "Yeah, I'll bond you out." So he sent us the promissory note and the agreement. We signed those, sent them back from the CBSA Center, the Canadian Border Services Center, and we learned later that these documents were declared invalid because they were created in Canada, where commercial bail bonding is illegal, and this kind of act to hire commercial bail bondsmen in Canada is a felony. But the bail bondsman, after agreeing to bail us out, we contacted him the next day, a couple of hours before we were supposed to be taken back to the border, and he said, "I can't bail you out. I can't do it. The court clerk lost the paperwork, your paperwork." So that very same day, on October 27th, 2010, he went and filed these bonds for $500,000 apiece without telling us. He gave us no notice for our court date, and these are the bonds that the district attorney and everybody is all raving about, but they don't exist. 3 years after this, we city and the bondsman had committed 8 violations of their regulations. Most notably, there was no security, there was no agreement, there was no collateralization or promissory note, and there was no notice given to us. I have this document, I have all the documents I refer to if you'd like to see them. But then my wife was found to be actually a Canadian citizen when we were in detention because her father, who lives here in Vermont, was born in Canada. So that made her Canadian, and that's why we were able to stay there so long. Well, I went through a process of, becoming a permanent resident while we figured all this out, and we did eventually, we think, get pretty much to the bottom of it.
Mr. Quaid, I'm going to stop you right
Okay.
there. Mr. Langrock, do you have any support for any of this?
Excuse me?
Do you have any support for any of this?
Yes, Your Honor.
What do you have?
We have I have a whole grouping of documents. This is from Department of Insurance. These were facts from this morning. I have not had a chance to read them in full.
So Mr. Quaid is explaining this to the court. Do you want the court to consider any of this?
At some point, Your Honor, we do.
Okay, at today, because Mr. Quaid is explaining this, but right now the court has nothing that validates anything that he is saying. What the court has in front of it now is a $500,000 warrant from a judge in California. Mr. Quaid seems to be talking about some failures on the part of the bondsman.
That's right, Your Honor.
Okay, the court doesn't see a connection to the invalidity of the warrant in front of it.
I probably in a half hour could get some of the documentation from this that was faxed to me. I got this.
What are you requesting now? Are you requesting that the court consider whether it will set bail in this case today, or to consider some of what you have there?
We're asking the court to set bail today. And in connection with that, I'm perfectly happy to have my client under oath state the same things he stated, and that as he's taken upon himself to do so, and he would have that before. Given the nature of the...
Okay, again, what Mr. Quaid has explained is that there was some failing on the part of the bondsman, but nothing that undermines the November 2nd warrant by Superior Court Judge Donna Gett.
I have to check before me, Your Honor. The Department of Insurance indicating that Mr. Quaid made a complaint, and just recently the complaint was justified because during the Department's regulatory review it was noted that the response was missing several items of information. And it goes on, Mr. Quaid, I don't read all here in court.
If you want the court to consider it, the court will consider it.
Yes.
What are you requesting? Are you requesting, again, that the court set bail at this time, or are you requesting that the court consider these additional documents? We have to come back in 3 days anyway in order for the court to review probable cause.
I would ask the court to set bail today, and based upon that this is a Vermont proceeding, and that there is no real showing here that he's in danger of flight. The only he has a passport, he has no place to flee to, and that this is what it's really about. Not that he should be held in jail because somebody in California, in a rather complicated situation, set a high bail, which is inconsistent with the charges.
I don't disagree with you that $500,000 is high bail for what appear to be property crimes. However, this court is not looking just at the relationship between the bail and the alleged offenses that occurred in California. The court is considering the fact that this warrant was issued 5 years ago, almost exactly 5 years ago, and that Mr. Quaid has been in Canada that entire time. There may have been some defects with the way in which his bondsman attempted to secure his release pursuant to the $500,000 bail. But the court doesn't hear anything today that undermines that bail. And so the critical facts in front of the court now are his absence from the country for 5 years and no attempt to rectify the situation with the court in Santa Barbara. The court is going to continue the $500,000 bail that was previously set. We'll be back in 3 days to determine whether or not there is in fact probable cause to hold him. And at that time, if you want to renew an argument that goes to the validity of the 2010 warrant based on some other information that you have, the court will fully consider it, and Mr. Hughes should have a copy of that as well.
In response, Your Honor, I appreciate the court's rule, but the court seemed to indicate it was concerned with my client being in Canada for 5 years. There's nothing inappropriate about him being in Canada for 5 years. There's no indication in the files that he fled the country because of this, and he attempted to gain Canadian citizenship.
Regardless of whether or not he was in Canada, he failed to return to California for 5 years.
I know no duty, Your Honor, for him to move from Canada to California to answer these charges.
The court's not indicating that he had to move. It is the fact that he failed to return to answer for the warrant. So, was there anything else, Mr. Hughes?
No, Your Honor.
So we'll be back in 3 days.
Thank you, Your Honor.
Okay. I'm not going to amend it on arraignment day. No, I need you to talk to Heather Brody.